You guys are. So since January 1st, we've had a wave of new California property laws. If you own or rent property anywhere in California, a lot is changing this year. And the best part is the confusion has already begun. On some of the videos we've released, we're getting tons of questions. Tonight, we're going to go live with California Property Law Group. We got our buddy Kenny Lim live with us, and he's going to help us break down what's actually changing and how these new laws, plus some old laws, are playing out in the courtrooms right now. So on the menu tonight, it's the 1-year anniversary of AB 2347. That gave renters 10 court days instead of 5 to respond to an eviction. So we're going to hear from Kenny how this has been playing out in the past year. Here's an oldie but a goodie. There's still confusion around the Tenant Protection Act and whether missing an exemption deadline really means it's gone forever for the properties that are exempt. This one, the new stove and fridge mandate, fundamentally changes what habitable means in California. And this has been confusing the heck out of landlords and renters. And we're going to explain why. We're going to talk about what landlords are legally responsible for after major disasters like the LA wildfires. And then one of the biggest pain points for everyone is the return of the security deposit. So a new law has finally modernized that. So we're going to talk about that. Plus, all your questions. So just put them in the chat, get started, and we'll get to them. And Michelle's keeping an eye on things. And you're here. This isn't theory from an ivory tower. And this is not AI slop. This is us. This is real attorneys, what they're seeing right now. And you're going to be able to ask your questions live. Hey there, Christian Walsh. It's me with Wire Associates. Been helping renters and landlords understand their rights before things go wrong. Let's bring in the guy with the tie. Where's my buddy, Kenny Lim? Get in here, Kenny. There he is. Round of applause for Kenny. Thanks for coming, Kenny. Appreciate it.
Good seeing you.
So, Zach and Raphael, our other regulars, are not here because they're off looking at the new office. You guys got a new office coming?
Yeah, we're moving in about a month and a half to a new location. So it's exciting news for us.
That is great. And I heard it's going to be bigger so you can have 150 attorneys. No, I just made that up. That'd be that. I know the team's expanding always, so that's why you guys need the new space. And it's near the other one, right? It's not like you're moving to some other country.
It's about a mile away. We're not going anywhere. It's still going to be based in LA.
Still based in LA, but I'm making you guys work all throughout Southern California, as I always do. All right, so let's dive into it. So the AB 2347, which extended the response time to an unlawful detainer from 5 days to 10 court days, it's been a year. What are the changes you've seen in the year that law has been in effect?
So two things, and I think the first one doesn't really affect landlords or just litigants that much. The second one absolutely does. And I'm seeing it play out in a way that is detrimental for a lot of people. The first one is I'm seeing a lot less what you would call demur, or what are called demurs. And these are documents that people may otherwise hire gray paralegals to basically extend the time period for an eviction to go forward on. You're seeing less of those, mainly just.
Who files that? Sorry to interrupt. Is that filed by the landlord or tenant, or both sides can file a demur?
It's usually filed by the tenant in these cases. In regular civil cases, either side can file them. But in eviction cases, they're predominantly filed by the tenants.
And you're not seeing as many of those?
I'm not seeing as many of them just because of the extended timeline that you get to file the answer. Usually also, sometimes the demur was meant as a stopgap measure to give them more time to file an answer. Because the 5 days was kind of pitting against the interests of the tenants to say, give me an opportunity to actually see what my defenses are, to see what I want to say, and actually put something forward. So I'm seeing a lot less of the demurs. So you're seeing kind of somewhat, I guess, if you could say, a faster resolution to actually getting someone to file an answer, surprisingly. The other thing so the second point is that it's more difficult nowadays to properly get what you would call a 415. Essentially, when you file an eviction notice, every one of those eviction notices, and all the landlords all see it and the tenants all see it, it says, and all unknown occupants or unnamed occupants. Just because you put that on the form doesn't mean that your judgment is going to apply to unnamed occupants. You need to get what's called a 415, or rather 41546. And in order to get that, there needs to be a statutory time period to run for you to be able to get that judgment against them. Because of the elongated time period for people to have to respond to a lawsuit, you're seeing the time period not line up as closely for trials. Because let's say that you have multiple defendants in a case. If one of them decides to answer, the others do not, you could still ask for a trial as to the answering defendant. The other ones, you can either get a default, or if they answer, they'll show up with an answer at the trial. The problem is that until you get the time period to run for the unnamed occupants, you won't get it in time for the trial, because the trial is going to be in 20 days. Mm-hmm. So when the trial date comes, the court's going to ask you, especially if you come to either to an agreement, or let's say you get a stipulated judgment or a judgment after trial, the court's going to ask you, did you satisfy the requirements for the unnamed occupants to respond or to get a judgment against them? And the answer is typically going to be no, because weirdly enough, the time period for them to respond also extended. But the unnamed occupants are just a legal fiction. They're not anybody. It's just anyone that's not there.
I was just going to ask, so unnamed occupants, I mean, anybody could say that there's unnamed people that live in something, but they don't know for sure.
Yeah, so it really is what you would cover under what people call arietta claims or post-judgment claimants. So because at the time of judgment for possession, the court's only going to give you a judgment for the named tenants on the lawsuit. And then if you are able to get a default judgment as to the unnamed occupants, then the sheriff will be instructed to not take any arietta claims. Or they will be instructed to say, even if there's somebody that comes to you and says, I wasn't given the lawsuit, let me into the lawsuit, the sheriff will still be able to go forward with the lockout at that point. Because of the time period to actually respond to the lawsuit was elongated, not only for the litigants, but it also extended the time period for the legal fiction of the unnamed occupants to respond as well. So sometimes those timelines don't match up as well, and you're not able to timely get a default judgment if you too quickly ask for a trial date. And that's what we've been seeing, because typically we ask for a trial date the moment that we get an answer. Now you can avoid this if you delay the case by saying, we can ask for a trial right now, but let's just do a little bit later, let's just do a bit slower. But that's not how we like to work. We basically just, when we see that we can get a trial date, we get a trial date.
It's fascinating to me, because when we first started doing these and we first started talking, it was how long before we're going to get a trial date, and there was no worries about it being too fast for anything. It was going to be 6 months to get in front of a judge. So that's fascinating now that there's the other side of it, and that's why it's important to use professionals like you guys to make sure that you're picking a trial date that's going to work and satisfy this as well. So
operating business as usual for a lot of the trial courts and the jury trial courts as well. A lot of them, just because you get a trial date, that doesn't mean that's the date that the trial is going forward on. There's many times where they can't find a jury trial court judge that will take your case on, or there's no jurors, or they want to go over your binder, or there's an FSC. Those kinds of things still occur. But the thing of it is that unless you get a trial date on calendar, you can't push your case forward.
See, everything you just said right there is another reason they need a pro. Like, I don't want to worry about any of this. Like, you're talking about a binder looking over, like, I don't want to worry about this. I just hire a California Property Law Group. You guys worry about this. So that's interesting. So that's one of the unintentional side effects. So they extend, it seems like going from 5 days to 10 days doesn't seem like a big deal in general, but it's changed a lot of things.
Well, if they just didn't apply it to the legal fiction of unnamed occupants, that would work. But I understand that there might be some individuals in certain eviction cases that aren't named because they either aren't on the lease or they just, did never notify the landlord they were there, and the landlord had no idea.
Yeah.
It's just the issue really is that when you extend these time periods, lining them up neatly for trial on the first date is becoming harder because you're not legally allowed to do that. You have to wait for the extended time period now.
Got it. Okay, we're going to move on to quick note that LA County extended the price gouging protections to February 27th, 2026. Not surprised because they've continued to extend it. It's related to the LA wildfires, been now going on for over a year. This triggers Penal Code 396. And what that means is that for real estate, you can't charge more than 10% increase in rent. Obviously, if it's under a more strict law like the rent stabilization ordinance and your increase is only 3%, you go with that. But if a renter moves out anywhere in LA County that's unincorporated or incorporated, the maximum the rent can be increased for the new tenant would be 10%. So anyway, that's one of the fun parts of it. So that's been extended yet again, and be prepared for that to continue to go on. Okay, Kenny, anything to add to that? Because I want to jump into the stove and fridge law. This is exciting.
No, we can go to the stove law. I think that's been the hot topic for a lot of people.
Hey, I saw what you did there. Hot topic, stove. I get it. I get it. Good. AB 628. So what it did is it modified habitability standards in the state of California. So if you're in California, you fall under the law. And what it means is that in order to have a habitable residential rental unit, you have to have, amongst other things, like heat, running hot and cold water, free of pests. Those are habitability standards. But now it's got to have a working stove and a working fridge. Now, Kenny, this has been fun. I released some content on this, and I've gotten a ton of great questions, and I know Elise already has a good question. Elise is watching, so is All Nighter. We'll start to bring in their questions in a bit. So the stove has been less controversial. People get that one. Although I've had some good questions, like if the landlord's only provided a hot plate, or another good one is, what if the oven is broken but the stove works? So what are your thoughts on those, Kenny? Like, what is the intent? Is stove meant to be a broad word, or is it a very specific word in the law?
No, it's mainly meant to generate. It's defined as something that would safely generate heat for cooking purposes. So if it's like a hot stove or like a hot surface, that kind of thing, you should be in the clear and good to go.
How about a rice cooker? Would that be sufficient?
No, I think they mean more in terms of like
Yeah, general.
actually like a hot surface, like pan kind of cooking kind of
Somebody
style.
asked me if an air fryer was sufficient.
I don't
Yeah, I
think
mean,
there.
it's close. It's a good one because you can cook a lot of stuff in it. But yeah, I don't think an air fryer is sufficient.
The way that I would view it is if you were defending your position and saying, I supplied an air fryer to my tenant, to 12 random strangers, would you be able to do that with a straight face? I don't think I'd be able to, if that was our argument.
Yeah.
Especially considering the alternative, which is getting a stove, isn't going to be that much different for the landlord at that point.
So think about going in front of a jury and trying to explain your air fryer instead of a stove. Okay, so the stove I think is pretty clear. Oven stove combos and one being broken and one, like, that's where it gets a little murky. But I mean, look, to be safe as a landlord, my recommendation would be make sure your ovens and stoves work. An oven not working that could catch the house on fire could be a bad thing. So just fix the darn thing, right?
Yeah, one of the things also that's interesting is you're going to actually have to follow through with the manufacturer sometimes too now, because if there's a recall, that is per se uninhabitable now. So if the type of stove or type of refrigerator that you've supplied has a known recall now, you must replace it. And you cannot allow your tenants to use the now recalled stove or fridge. So depending on the manufacturer quality, that might affect how long you're going to have to keep renewing these fridges or stoves.
Yeah, and it's very quickly the used stove market is going to be evaporating because people are going to buy them to put them in their rentals. Here's what's interesting. So we'll go into fridge in a second, but what's interesting is it's actually historical tradition in some areas to provide stoves and fridges anyway. So this is nothing new for a lot of areas. And then some areas you don't get a stove, some areas you don't get a fridge. So it's just interesting. But now let's talk about the fridge. So the fridge is going to have statutory language. So going forward, and we're going to discuss exactly, we're going to talk about who this applies to in a second, because this is a big deal. But going forward, any new leases in 2026, there's going to be statutory language. California Association of Realtors lease already has it, and it says under state law, the landlord is required to provide a refrigerator in good working order in your unit. By checking this box, you acknowledge that you've asked to bring your own fridge and that you are responsible for keeping that refrigerator in working order. So that's in the bill itself. So what it's allowing is it's allowing tenants to bring their own fridge if they want, optionally. Now, if they decide if their fridge breaks, and they decide, hey, I want the landlord to get me a new one, they can give a 30-day notice to the landlord telling them to replace it. So, Kenny, let's talk about what it says. So, what it says in the law is that the new fridge and stove, technically, shall only apply to a lease entered into, amended, or extended on or after January 1st, 2026. So it's easy. You move into a new rental in 2026 or beyond, this applies. But for those folks who are month to month right now, what will trigger this law applying to them?
So any kind of amendment or extension for any kind of lease holding period is going to trigger this. And I think it was done intentionally, mainly because they just want to encompass as many people as possible. They just said, this is the way it's going to be for tenancy just moving forward, and that's just going to be the baseline. So the language of the amended and the extended, I think, does apply for month-to-month tenancies,
Yep.
because every time that you are accepting a new rental period, you are extending that rental tenancy period for another month. On top of that, if they've added another language in there just to solidify their thought process, which is amended as well, which basically, if landlords ever want to raise the rent on somebody, that's an amendment to a contract. That's an amendment to the lease.
Yeah.
So that's also going to trigger this as well.
That
And
was
again,
that was my gut on it, that it would be because a lot of land people have been month to month for years, and uh, but if a landlord decides just to give a rent increase, I think it triggers this, and that the landlord must now include that statutory language and must now take care of the stove and the fridge. You agree?
yeah, and the statutory language really only applies if the tenant is the one that is going to be supplying their own fridge.
Mhm.
And they're the one saying that I want to keep my own fridge, because there are some people that just are attached to their fridges. And the default rule as a landlord, if you're a landlord, you should be expecting to just go into it thinking that I'm going to be supplying a refrigerator and a
Yeah.
stove. That should be the default thinking for every single tenancy moving forward. Um, and for those that you don't have it right now, I would consider doing it immediately, because the way that this language is phrased, it seems to indicate that even for the month-to-month tenancies, they want to encompass those as well. And if you don't want to get potentially hit with an affirmative action habitability lawsuit, I would just get them a fridge or a stove.
Agreed. Yeah, I mean, think about it too. By updating habitability standards, it's not like by making it that core, because that's taking it to the bone. When you say it's part of habitability, it's not like half of California, there's rental units where they have heat and half don't. Like every rental unit has to have heat. That's required by law. So to your point, like this law is ultimately going to apply to every rental unit. So sooner rather than later is safer for a landlord. Would a renter be able to use this as an affirmative defense against an eviction if they haven't their fridge hasn't been maintained or replaced?
They would. And
Yeah.
that was the purpose of putting it into the habitability code section. So anything that's listed as a violation of the code section then triggers all of the protections for evictions. It also triggers all of the affirmative actions that a tenant can bring forward. I think it would be, I think their damages might be a little bit limited if the only cause of action is I wasn't given a fridge. If a tenant was to sue saying you violated my implied covenant of habitability by saying that I never got a fridge, your damages might be a little bit limited there. But the tenant can still absolutely sue for that. They're within their legal right to do so on that.
Fascinating. So, and yeah, just to reiterate, like tenant could stop paying rent, you move forward with the unlawful detainer, get in front of the judge, and all of a sudden it comes out that you didn't maintain the fridge, and you're back to square one. So,
Yeah, and then on top of that, you have to then give them a fridge.
exactly, and then start over if they don't pay rent. All right, let's jump to some questions, and then we'll come back to the new laws. Because Elise has a question about the fridge mandate. So we may have covered this, Elise. So with the new fridge mandate, what if a tenant's fridge went out sometime this year? Is the landlord obligated to provide one for tenants? Yeah, short answer between what Kenny and I are talking about, just do it. Ask them if they want to provide their own, and if they do, then have that language signed. But otherwise, be prepared to provide it for them, even if you haven't signed a new lease. You haven't gone that far, but in the future, you're probably going to raise the rent, which is going to trigger it. You
Yeah,
agree, Kenny?
so we're treating this, basically the legislature is treating this as if it's equivalent to you not providing a water heater, equivalent to you not providing windows, walls, doors, that kind of thing. And most people would not question, hey, my doors blew off. Hey, my water heater doesn't work. Does the tenant have to pay for it? That's the way that the legislature is kind of trying to say, hint, hint, nudge, nudge. It's going that way.
Yeah.
Yes, I think that if the tenant does go, or if the fridge tenant goes out, if the fridge goes out, the landlord should be looking to fix it. The only exception, and there is a carve out, the only exception is if it's the tenant's refrigerator that they brought in themselves, which at that point, any maintenance issues are to be done by the tenants and not by the landlord. That is the only exception.
Yeah, that makes sense. But what's going to happen, like I said, is the fridge starts to go out for the renter, and then the renter just gives that 30-day notice to get a new fridge from the landlord. So again, be prepared. All right, a few more questions, and then we'll keep going. Yada Tada is asking, can I sue for rent collected when registration was expired in an RSO multifamily for a year gap now coming into compliance? So what it sounds like is the registration expired, somebody didn't pay rent, and now we're going to go ahead and register it. But what happens for that period where they didn't pay rent, where the property wasn't registered under the RSO?
Yeah, so the obligation to pay the rent, it's contract law, it still accrues regardless of whether or not a landlord is properly registered with the proper rent control board or not. The only thing it really affects is the landlord's legal rights to evict somebody, and it affects their rights to enforce other parts of the contract that they would otherwise want to enforce. But the obligation to actually pay the rent is still there. So once the landlord comes to compliance, does everything they're supposed to do, they can then start enforcing it like they would have before. Now, with evictions, depending on how long it takes for them to get in compliance for rent collection, you can't go back more than a year. So if it takes the landlord more than a year, they're not going to be able to sue for eviction for more than a year's of the rent that wasn't collected at that time.
Yeah. Okay, that's fair. All-nighter, his Sub-Zero fridge goes with him wherever he goes. To your point, Kenny, some people are just attached to their fridge. I
Yeah, and the
get it.
legislature knew that. They knew that.
Now, what I had a good question in the fridge law, and the question was, does the landlord have to provide the fridge in the kitchen, or is a fridge in the garage okay? So
So there's no actual designation for where it needs to go.
yeah,
I imagine that if it's in the garage kitchen, as long as it's supplied, you should be good to go. But if the way that I view it is, if you're doing it to spite someone, you're going to cause more headaches for yourself. If you're
yeah,
doing it because they requested it, by all means. But don't do it just because you're saying, I don't want it in the kitchen for whatever reason, and take it or leave it kind of thing.
yeah.
The more normal you are in your interactions, the more normal interactions you'll get, and the more or the less problems you'll actually face in the long run.
So speaking of future problems, I can envision, because this next question is going to come, I know. Is there any requirement that the landlord replace the fridge with one of comparable size? Because I could see where we start to get into cases, and like you said, out of spite, somebody
Yeah, I
replaces
mean,
the big built-in Sub-Zero with a little dorm room fridge.
there is going to be questions about whether or not a mini fridge will work, whether or not a cooler will work, that kind of thing.
Yeah,
And they're going to have to actually deal with that in the legislature. They haven't actually defined it as clearly down the road as maybe I would have liked. But that's going to be something that is going to be up for litigation. Like I said, the closer you are to what the regular expected norm would be, probably the safer you're going to be.
yeah.
But if you want to push the edges, I would say bare minimum mini fridge, bare minimum. If you were to go lower than that, I think that you would have a harder time arguing that you're in the right, that you supplied a refrigerator that is functioning, that complies with what the law requires.
Yeah, that it'll be interesting. And so there's another kind of law question. And this is where Zach is fun, because Zach always quotes cases and case law number. But is it like the legislature obviously wrote this law? Is it up to the judicial branch to determine what it says, or is it up to the legislature to clarify it?
Yeah, so the judicial branch is always going to, and this is more of a, it sounds like a high school government
Yeah,
at this point. The legislature is the one that wrote the law. Clearly, they're the ones that wrote it and just put it into place. And the judicial branch, the courts are going to be the ones that are going to be interpreting it. So if it just simply says refrigerator, it's going to be up for interpretation. And again, this kind of reminds me a little bit about what when the legislature put down, you have to say the number of bedrooms on the notice. And I kid you not, this is an argument that I've had to make multiple times because there was an interpretation of what does bedroom mean. And the reason being is that a landlord on their notice put down your unit has a studio. And there was an open-ended question as to whether or not studio is a bedroom. And so there was questions about, does that satisfy the requirement to state the number of bedrooms?
right.
And there was a question about, well, how many people know how many bedrooms a studio has? Is it common knowledge? Is it not common knowledge? And that was the interpretation style that you had to go down. But the thing of it is if you have to litigate that out and argue that out with lawyers when you're trying to just get a result, the best, easiest way is to not even have that argument, is to just comply with the literal words on the page so that you don't get the ambiguous kind of questions and answers that you would get with, what is a studio? Is that a bedroom? What is a fridge? Is a cooler a fridge? Is a mini fridge a fridge? I can tell you what is a fridge or a refrigerator, just a regular refrigerator. I can tell you that. So
Yeah.
if you get a regular refrigerator, you're not going to get these kinds of questions. And you're not going to be paying for legal fees and attorneys to make these arguments for you.
Yeah, that's an expensive way to comply with the law, is to go ahead and attempt to justify and interpret it in front of a judge. Well said, and I appreciate you clarifying that. So Yadatada was wanted to further clarify the question on the RSO unregistered property. Can the tenant sue for the rent paid for the period of time that the registration was expired? So basically, what the question boils down to was, Because it wasn't registered with RSO, was the landlord legally allowed to collect rent at that point in time? Because now it looks like the renter is going after the landlord, saying it was illegal to collect rent when that property was not registered. What are your thoughts on that?
So there are certain cases that are going through the court systems right now where that's still an open-ended question,
Okay.
where there are tenants who are suing for the paid rent to where the landlord wasn't illegally demanding the rent for that period, and it's still up in the air on this. My interpretation on this is that it's the one clear answer that we do have is that regardless of whether or not the landlord was able to demand the rent for that time period, the rent does accrue. The benefit of the contract was still there, where
Mhm.
the tenant did stay in the unit for that period, and there was a contract, notwithstanding what the law says in terms of demanding it, but there was a contract that said, for this unit, you're going to be paying X amount of dollars for that unit. And I have seen some courts side more on the contractual side, saying there is a contract for that. The damages are there, where the tenant does owe the rent because they were able to use the unit pursuant to that contract. The only thing that, again, it restricts is the landlord's ability to demand the rent or evict you over it for that time period. So they can't evict you for it, but they can absolutely demand it once they get in compliance.
Yeah, and that's an excellent distinction. So the landlord can evict, but the landlord is still entitled to collect. Now, where that doesn't apply is a bootleg unit, correct? A bootleg
Yes.
unit that's completely illegal. It's not a valid rental unit. That would be the distinction where you're not able to collect the rent as a landlord. You
Yeah, and the logic behind that is it's the equivalent of the court condoning illegal behavior as a whole.
got it.
So let's say that I had a contract with someone to buy thousands of pounds of heroin, and
and the
I
and I
paid the guy.
stiffed you, Kenny. I stiffed you on the heroin.
Yeah, and I paid the guy, and the guy never gave me the heroin. I go to court and I say, hey, look, we had a valid contract. I paid the guy. He never gave me my heroin. The court's not going to enforce that contract
Yeah.
because the contract itself is illegal. But if you're talking about a housing unit that is legal, you have a unit where the tenant was renting it out. The landlord, through an ordinance or through law, can't demand the rent, but the actual rent does accrue. So the actual rent is owed up until the landlord becomes compliant with the RSO laws. They cannot demand it, but the rent is still owed.
Yeah, that's a very it seems like a fine distinction, but when you put it that way, it makes complete sense. So, um, thank you for clarifying that, and I'll make sure I get you your heroin. Completely a joke, by the way. Kenny did not buy heroin from me. So all nighter talking about bedrooms. He has a closet to build in one of his units in Gary, Indiana, to make it a legal bedroom for Section 8. And it's only natural to have a closet with a closet rod and a shelf. So there is a definition of a bedroom. If there's a closet rod and a closet. So all right, let's go back to some of the laws, and then we're going to get into the Tenant Protection Act, which I know Kenny loves. So SB 610, the post-disaster landlord responsibilities, that was inspired by the LA wildfires and essentially sorting out who's responsible for what. So Kenny, I'll let you jump in, but basically the law was saying that if a unit was completely destroyed or severely damaged, the landlord didn't have to build it back. Which is what you and I actually did a video together a year ago talking about just after the wildfires. It's one of our most popular live streams. And then the tenant, if there's an emergency evacuation, the tenant is not responsible for rent during that time, nor is the tenant responsible for rent while the unit is uninhabitable. The landlord must use licensed contractors for remediation, and the landlord must share any reports that they've purchased with the tenant if the tenant asks. Anything to add to that, Kenny?
No, that's pretty much it. I think you mentioned this too, is that there are some landlords who decided to just take it as a total loss, where if the unit itself is just destroyed, there's a statute and case law that talks about If the hired thing is destroyed, then the contract is over. You don't have to rebuild it. So if the entire unit is rebuilt or destroyed, the landlord is not under any obligation to rebuild it and then put the tenant back into that unit at all.
Yeah.
So yeah.
Oh, one other important thing, once the unit is habitable again, so this isn't one that was destroyed. So this would be, for example, a unit where there was smoke and ash that maybe got into the unit. Once it's remediated and the renter can move back in, the rent stays the same. A landlord can't charge extra for that. So that was one other thing that was important. Okay, last new relevant law. There's a few others, but I think this is a good one. It's AB 414, security deposit modernization. So up until now, landlords had to physically mail a check to everybody whose name was on the lease for whatever security deposit was left over. They had to make sure they had their three sets of pictures, which is when the tenant moved in, before, just after the tenant moved out, and then after any work or cleaning that was done to do deductions. So those had to be emailed, blah, blah, blah. Now a landlord can actually send it electronically, send the deposit electronically, and tenants can choose who the deposit goes to. So Kenny, tell us your security deposit best practices, just a quick version of that.
Yeah, so I mean, everything is shifting electronically. The legislature is catching up on that. One of the things that it does require is that if you ever receive the security deposit electronically, you are required to send it back electronically as well now. And you should always get the tenant's latest email address so that you can actually just send them the itemized deduction report there as well. And it works out for everybody much better because you avoid sometimes the, I guess, for lack of a better word, lack of notice of the actual return or itemization of the security deposit, and you avoid the potential small claims lawsuits that I've seen where it was just a misunderstanding or a hiccup where it was mailed to the last known address, and the last known address to the landlord is typically the address the tenant just vacated. Whereas with an email address, it's a lot easier, it's a lot clearer, it's a lot easier to prove when, where, how, and what you sent over. And whether or not someone actually received it or not is not really your concern, because the email, if somebody decides that they're not going to open up their email inbox, that's not really an issue for you. The only thing that you control is what you sent and what you did. So if you can prove that you sent it to an email address that was verified by the tenant, that really safeguards everybody involved because there's an actual record of what occurred. So best practices would really just be accept electronic forms of payments, and then also get a record of the email address of the tenant so that you can actually have that email correspondence along with the being able to send the security deposit itemization form via email.
One other thing to add, it's just a random note, but I'd like to throw it in there. So the new California Association of Realtors lease does a better job of documenting the security deposit. And I mean, there is more to add. Like security deposits, for the most part, the majority of landlords now are only able to charge 1 month's rent for security deposit. That was a big change we had in 2025. There's a few exemptions there, but the other big one in the California Association of Realtors lease changed is when agents were involved with the leasing of an apartment. What would happen is that in some cases, the agent's fees were basically being deducted from the security deposit. The renter, in making out a check, was going to make out a check to the brokers, and then the remainder was going to go to the landlord. Long story short, if you're going to do this, which I think is a terrible practice, I think the money should go directly. The move-in rent and security deposit should go directly from the tenant to the landlord. But if an agent's involved and the agent wants their check, they're all excited to get their teeny tiny check. Document it, because there's confusion then at the end when you're attempting to return the security deposit. In some cases, I've been there where the tenant says, no, I paid you this. The landlord says, well, I only showed this for the check. So anyway, document everything, which is what Kenny says all the time anyway. So, okay, Kenny, it's time. Tenant Protection Act, your favorite. I know how much you love to talk about the Tenant Protection Act.
This will never go away.
I know. Well, here's the interesting update. So the Tenant Protection Act went into effect July of 2020. It is a 10-year law. It's theoretically sunsetting in 2030. Well, we're over halfway now. We're into 2026, and people still don't know about the law. So I don't know. Maybe at some point in time they'll get it figured out. But
it'll go as long as the LA County keeps extending the the anti-housing statute.
No, in all seriousness, there was very recent legislation, and I've stopped covering recent legislation until it passes because it changes so darn much. One of the new laws for 2026 is the Social Security Tenant Protection Act. That law actually started out as a rent freeze for LA County, and it morphed into a Social Security Tenant Protection Act, which basically says you can't be evicted if your Social Security is stopped through no fault of your own, like a government shutdown. But anyway, I digress. So one of the other pieces of legislation this year that just was killed was going to reduce the maximum rent increase to a total of 5%, and it was going to remove the sunset in 2030. So long story short, to your point, Kenny, get used to the Tenant Protection Act because it's most likely going to live beyond 2030. And I hope you and I do live beyond 2030. Okay, so I'm sharing something right now that is from a tenant attorney. I don't know anything about these folks. I just Googled this up, like my son Liam says. And the reason I did is because I was talking to a property owner who their property manager is saying that they have lost their Tenant Protection Act exemption. The property is exempt on because it's not owned by a REIT or an LLC, single family home, checks all the boxes. It is an exempt property, but the landlord didn't give the exemption language. In this, her property manager told her basically she could never get her exemption back. I disagree. You and I have talked about it, and you're going to tell us whether that's true or not. But if my gut was that her property manager was using AI to get the answer, and I used AI to get the answer, and I found where the property manager got her answer. And it is basically one of the places is here. These are tenant attorneys. They may be great. I don't know anything about them. Not judging them at all, but I'm just saying, I'm sharing what their article shows. And what it says is that basically, if you haven't given the exemption language, and they even have, this is from the California Association of Realtors. This is the RCJC, the Rent Cause Just Cause Addendum. So they pulled it from here. And this, I find this a lot where the agent or landlord didn't check that box, which means that the property is not exempt. You have to check the box. So what they're saying here at this law firm for tenants is that it's gone. The landlord can never get it back because for new or renewed leases after July 1st, 2020, it must be provided at the start of the tenancy. If there was tenants that were there before, the notice had to be provided no later than August 1st, 2020. And basically says it's gone. But what's interesting, it also says that's what some attorneys and some tenant attorneys and rent boards interpret as it's gone, you can't get it back. But landlord attorneys argue otherwise, that you can get it back. Now, the ways we've talked about getting it back on this show are if the renter was in possession before July 1st, 2020, and you didn't give the exemption language yet, you can basically just hand it to them and they immediately have the properties exempt. If it was after July 1st, 2020, they moved in, you have to give, and they're month to month, you give them the 30-day notice of change in terms of tenancy with the exemption language, and 30 days later, it's there. Kenny, I'm queuing this up, and I know I'm going deep into this, but you're in front of judges, and you may have heard a tenant trying to claim that the landlord does not have the exemption. What happens in court when you come across this?
Yeah, so the thing of it is the real kind of thing that the court looks at is what did the landlord do? Did they ever give notice at all? Was a notice just given too late? When was it given? Now it sounds like I'm going down this idea of substantial compliance. That's not where I'm going with this. Anytime you see a landlord attorney make that argument in court, you know they're floundering. But the court really is trying to see if the exemption notice was ever given, and the way that it's written out, the E8 exemption says that it has to be in the lease agreement, provided in the rental agreement.
I actually pulled up the law, Kenny. This is Civil Code
1946.2
1946.2, and I've
E8.
highlighted that section where it says it. And what's interesting, and I shouldn't interrupt the attorney because you're just getting rolling, but it says that the addition of the provision containing the notice required to any new rental agreement or fixed term lease. So basically, you can give it in the future. It's not like you missed a deadline. Like you can give it in the future. So keep going. Sorry.
Yeah. So the intent behind the legislation wasn't that if you miss a deadline, so long's goodbye, you lose it forever. You can incorporate it into your lease agreement. And the way that you would do that is through Civil Code 827, where you can amend lease agreements to have anything in them. And the weird thing about 827 is that it applies for residential contracts, lease contracts, and commercial. Very rarely in other contractual contexts would you be able to just unilaterally amend a contract. But when you amend a contract like this, what that means is that the contract literally has those words in it. You amended it to read it into there. So let's say that you had a contract that unfortunately was after July 1st, 2020, and you just didn't have that language in there, but you still qualify for all of the E8 exemptions. As long as you're on a month-to-month, you can then serve an 827 notice. You could then incorporate the language required to give you that exemption back and let the tenant know, hey, here's your notice. You're actually exempt from the TPA. Here you go. After 30 days, we are exempt from the TPA. You can do that and it'll incorporate itself into the lease and it satisfies the language required under 1946.2. And I've seen courts accept that argument, indicating that it is now incorporated into the lease. So there's no reading of it that says that it's not part of the lease at that point.
That's exactly what I wanted to hear, is what happens in practice. That's important to understand because you read the legislation and that's one side of it, but the actual practice of the law and the way you just described, putting it into the language of the lease, that makes all the sense to me in the world. So when
I will say this much, one thing really quick is the way that certain cities in Southern California are going, you may not even have to argue this for very long because every city is just going to have their own protective versions. LA, most of the time in LA, you're not even arguing the TPA because you're never going to be subject to the TPA.
Yeah, exactly.
It's always going to be the LA city version.
Yeah,
and you might start seeing that in other cities as well. But again, like I said, for the TPA, the real argument and the real way you get out of it is you incorporate it into your lease. That means that you get your exemption.
Yeah. Yeah, that's it. At the end of the day, the way to do it is to continue to watch videos like this, hire professionals, and make sure that when you do a lease, don't draft it yourself. Don't even use Zoom documents or whatever. I don't even know those names of the different Rocket documents. I don't know. Don't use those things. You either join an apartment association or use a real estate agent who knows what they're doing and use the most recent lease. And don't be afraid to update your lease every once in a while because you basically got a lot of stuff to continue.
The thing of it is also...
Did I lose you, Kenny? You froze, buddy. There you are. Good. You're back. Go.
Yeah. That the car association form that I've seen, they have, and God bless them, they have an opt out function. It's not an opt, or it's an opt in function, not an opt out function.
Yeah.
And the way they have it is, if you are exempt, I need you to check mark this box. I cannot tell you how many of these leases I've seen where they don't check mark the box. They say, here's your TPA exemption notice, uncheck marked. And it's, clear as day where they were trying to say they were exempt, but for want of a check mark next to a box, they don't get that exemption now. And you have to go through this arduous, let's serve a notice to amend it back in kind of thing. So you need to actually read your lease. As strange
Yeah.
as it sounds, you need to read the lease, and make sure that you're check marking those boxes off. And they try to safeguard as much as possible everyone's kinds of rights that they would normally choose, like the default route. But for the life of me, I can't understand why the association just said we're just going to make it an opt in and not an opt out. So unless you opt in and saying that you're exempt, then you're not exempt.
Yeah, it's true. It is just a box. And it is amazing to me that how many people can't just check a box. Okay, so let's see. I don't know anything about AB 1529 right now. Did AB 1529 pass? Anyway, sorry about that. Bay Area, California real estate. We'll do some digging unless Kenny's got something to add. If it hasn't passed, which it doesn't look like it did, if it hasn't passed, no, it says filed with Secretary. Well, sorry about that. I feel like I've let you down because normally I've got an opinion on everything. So we have a good question from Carla. Can the notice be given in the form of a letter without adding it to the lease? Yeah, Carla, it can be a letter. A letter, as long as it has the statutory language on it that says that the property is exempt with the appropriate 1940. I should just put it back up. It's in there. It basically, there's specific statutory language that needs to be on there. If that's on there and you gave it to the renter, in your case, because I talked to Carla, I know your renters were there before 2020, July of 2020. So you were able to just hand it to them. You didn't have to give the 30-day notice to change in terms of tenancy. And yeah, it's a letter's fine. Doesn't have to be fancy. And they actually, go ahead,
I will
Kenny.
say one thing. With these forms, though, these forms are not the time to kind of be like pretty with like flowery language
Yeah.
and like adding your own stuff, because there have been times where I have seen people say, "Hey, look, like you gave me the proper notice. Like you told me that you were exempt. Everything's fine. Everything's good, but you forgot to copy and paste this last sentence that's required, or like this one word that you left out." And I've seen judges say, okay, then you're not exempt because you have to have all of the words on that notice in your notice. So that language in the 1946.2 E8 language, copy and paste it, the entire thing. There's no reason why you would skip ink on paper at that point if you're going to give the notice to get the exemption. And don't try to summarize it. Don't try to paraphrase it. Just copy and paste it at that point.
Yeah, statutory language. Whenever you see parentheses in the civil code, whatever that says, take between the parentheses and put it on the paper. There's that's it. Yeah, and she provided it with the notice of non-renewal, but they were there before 2018. And then I did just double check that the question about AB 1529, it did pass, and it's specifically related to assisted housing development and subsidy contracts. So we'll add that later. That's kind of a niche thing that we don't have much experience with. So sorry. Okay. Holy cow, Kenny, it's almost an hour already. How'd that happen? We're having so much fun. One more question for you for the Tenant Protection Act. So I have a client who has a single family home exempt from the Tenant Protection Act. They've been given the exemption language. It's one renter who rents out the bedrooms in the house. Now, the landlord knows about it, but it's not like the landlord necessarily knows who's living there. And they exceed the 2-bedroom thing So anyway, long story short, is that property still exempt from the Tenant Protection Act when you have 5 different renters or not?
So I just want to make sure here, the landlord is renting out a single family home
Yeah,
to a single renter, and
yeah,
that single renter is subleasing it to multiple different renters.
correct. So she's in 1 bedroom and the 4 other bedrooms, she's subleasing to them. So the landlord takes the check from that one renter he's renting to, and he's aware of the situation. Nothing's being done under the rug.
Sure. So there's like multiple levels here. So basically, the landlord to the main master tenant, you're still exempt from the TPA. You're still a single family home like you normally would be.
Okay.
The sublessor or the sublessor to the sublessees, you wouldn't be subject, or you would be subject to the TPA.
Got
But
it.
not only that, if you are doing this unpermitted, you may run into our previous example about what illegal contracts would look like. And accepting money for illegal contracts may not be enforceable if you are leasing out or treating a single family home and leasing it out like a boarding house without the proper permits. So that
Interesting.
may become a problem in the event that the sublessor is trying to enforce their rights against the sublessees.
No, that's an interesting distinction. I didn't think of that. So, and just another level, when people start to lease out bedrooms, I know Kenny and I came across someone leasing out a lot of bedrooms once. We won't go into that. Okay, so we're coming up on the very end. Why should we hire California Property Law Group, Kenny? What makes you guys different from the other eviction attorneys out there?
So we will always be upfront about everything that we're doing. When it comes to the actual knowledge that's required for evictions, it's been evolving quite rapidly. And unless you're actually in the courts, unless you're actually interacting with the courts about how they're interact or how they're interpreting what the law says, you're going to get people that are going to be refiling their third, fourth, fifth, sixth eviction because it's going to be strict compliance, strict compliance. I joked earlier when I said, hey, look, like there are some attorneys out there that are going to be making a substantial compliance argument. I joke about it, but it's a sad joke, really, because I have seen it. And I have seen the earnestness in them saying this is a proper legal argument. And unfortunately, if you're going to make that argument, you're best starting the case over at that point. But people will file these cases without knowing what the law is. And if you don't know what the law is, you're just going to be wasting time, money, and effort. Because we know what the law is, we don't do that. We know what the law says. We take your facts and we will tell you whether or not you are going to win your case or not. There are many, many situations where you have to fix your situation first. And unfortunately, there are times where you have to fix what you're doing first, and then you can bring the right lawsuit and you will win your case. We provide that guidance. We provide that stability and understanding of why you're doing certain things, when and where and how you're supposed to do those things. So that's why you should hire us, because we give you that guidance.
Well said, Kenny. And I'd like to add as well, you look at Kenny and he looks like a young guy. He has a lot of Botox. He's actually 65 years old. But no, I only jest. Like some people think, oh, well, the California Property Law Group, these are young guys. What do they know? The past 5+ years now, we have seen more changes in landlord-tenant law than in the previous 250 years of the nation. So the fact that they've been actively practicing in the courtrooms, in the toughest place in America in some cases to practice law, which is LA, for landlords, that's where these guys have been working hard, winning cases. So please don't let that dissuade you, the fact that they look young. These guys have crazy amounts of experience. They will guide you in the right direction. They don't want to just take your money, and you can actually get them on the darn phone. So it's like this crazy assortment of things that you never hear about attorneys. That's what these guys do. And that's That's why I'm partnered up with them to do these live streams, and I send all my business, all my clients go to these guys. I don't get a penny of it. I send it to them because they're the best ones out there. So anyway, that's how I feel about it, Kenny.
Appreciate the kind words, Christian.
Of course.
It's always a
All right,
great
so
time
we're-
hanging out with you guys.
We've all-nighter. He's got a buddy who's successfully running a property in Arizona with a bunch of bedrooms rented out. Of course you do all-nighter. You'd always have somebody. Six of the bedrooms pay the utility, 7 and 8 of the profit. So as long as he doesn't have any vacancy in those last 2, he's making money. So I'd also like to say, number one, thank you, Kenny, for being here. We're now over an hour. But number two, before you move forward with anything as a landlord, whether you're looking to figure out whether to evict a tenant or not, call Kenny in the group. And then the other side of it is, if you're a landlord thinking of selling, reach out to me and I'll guide you in the right direction. And we'll bring in the California Property Law Group when we need to. That's part of what I provide as well, is knowing who to turn to at the right time. So that's it. I'll get off my soapbox. Have a great night. Thanks for tuning in, and we'll see you on the next one. And I want the whole team, I want the whole band back together, Kenny. I want Zach, Raphael, you, and Christina. Get her on too.
We'll see what we can do.
Thanks, buddy. Take care.